Okay, let's get right into it. This is my favorite part of Chapter 7, the discharge. Why? Well, the discharge usually signals the end of the case from a procedural standpoint. Let's say, for example, you have assets which need to be distributed. In other words, when we talk about bankruptcy and property, there are certain assets which are exempt and certain assets which are non-exempt. So let's say you have about, just make up a number, $5,000 of non-exempt assets. Well, that $5,000 of non-exempt assets has to be paid to the trustee, or you give the trustee something. For example, let's say I have 3 things on my desk, 4, and the trustee says, okay, these are non-exempt assets, and I agree with her. And these things are worth $500. Well, I can tell the trustee, I don't want them. You take them and you sell them and give that $500 to my creditors. Or I would say, no, I want to keep this stuff, and I'll pay you the $500 or $5,000 or $2,000, whatever the number is, over the next couple of months, and then I'll wash it out. In other words, I'm buying back my interest in the non-exempt assets. So on one side, you got the unsecured creditors. On the other side, you got the non-exempt assets. As long as you're willing to pay your creditors at least as much as the non-exempt assets, that's really what the trustee is looking for you to be fair to your creditors. That's what the bankruptcy code requires. That's what the trustee's job is, to make sure you're fair. So now, what happens? You get your discharge ultimately, okay? I like the discharge because the discharge contains what's called a permanent injunction. Any debts which have been discharged through that judge's discharge, the judge will sign an order. It's an order from the court. Basically, it's a piece of paper saying the discharge of the debtor. You get that discharge. Along with that discharge comes a permanent injunction against any creditor from ever trying to come back against you and collect this debt. A lot of creditors don't think it applies to them. Why, I don't know. But if they get notice of the bankruptcy and they're actively participate in the bankruptcy by filing a claim and attempting to be paid, and then they try to subvert the discharge order, we're going to reopen that case, or if it's still open, we're going to go back in there and ask the judge for relief for you. And the reason why is, you got to think of it this way. You have a constitutional right to file bankruptcy. When you enter into a contract with a creditor, you sign a contract which gives them basically all the power. Let's just use a credit card agreement. You miss one payment by 1 day, and what do? Oh, the contract says, we are allowed to raise the interest rate, and it goes up to 29%. How are you going to pay that back? You probably can't. Now, the funny part is, when you try to invoke the discharge injunction or the power of the discharge injunction, you ask the bankruptcy judge to enforce that order. You should see the arguments that the creditors come up with as to how this didn't happen. Oh, it was a rogue employee. How we didn't know. We certainly didn't mean to violate the debtor's right to the discharge and the permanent injunction. Then why did you call the debtor 100 times? Yeah, I had one like that. Over 100 times they called him. Imagine that one. That was a rogue employee. But the other ones are kind of laugh. They laugh because, oh, this is all about attorney's fees and this is all about this. Well, yeah, if you violate my client's rights and I bring you into court and I'm right, and I'm going to ask the judge to allow my attorney's fees. There's nothing wrong with that. But again, that's their argument, not that we screwed up and we intentionally did this.